Okay, so happy lunch, everyone. We're your lunchtime entertainment. My name is Rania Khalek. I'm a journalist. I'm an independent journalist. And we are going to have a discussion that's going to be a little bit more informal than the presentations we've already seen today. So we're going to talk about criminalization and due process in deportation proceedings. Basically, what I want to do is I want to try and have a conversation with these three wonderful individuals about sort of the immigration experience from beginning to end, from, you know, the law enforcement aspect of getting arrested or detained, and then, you know, the court proceedings and the, you know, treatment and detention, and then the actual deportation if it does happen. And with me I have Lindsay Marshall, who is the executive director of the Florence Immigrant and Refugee Rights Project. And the project provides free legal-related social services to 3,000 men, women, and unaccompanied children detained on any given day in Arizona for immigration proceedings. Prior to this position, Lindsay was the project's pro bono coordinator, where she recruited volunteer attorneys in the community to take cases on. Lindsay holds a JD from Northwestern University School of Law and a master's degree in criminal justice policy from the London School of Economics and Political Science, and a BA from the University of Michigan. My God. She's been with the Florence Project since September 2006, and she serves on the U.S.-Mexico Border Policy Task Force and on the steering committee of the National Detention Watch Network, and regularly speaks to community members, peer organizations, and other stakeholders about the immigration detention and enforcement system. And we also have with us Jennifer Friedman, who is a graduate of NYU Law School, where she was an Arthur Garfield Hayes Civil Liberties Fellow. She's an expert on the intersection of criminal and immigration law and trains defenders, parents, advocates, and immigration attorneys on the subject across the country. At NYU, Jennifer was in the Immigrant Rights Clinic and on the board of the Review of Law and Social Change. She spent her summers at the Florence Immigrant and Refugee Rights Project in Arizona, which is where Lindsay works. And did you guys know each other? No. And during her studies, Jennifer interned with the International Center for Transitional Justice, the ACLU Immigrants' Rights Project, Immigration Equality, and the Center for Constitutional Rights. She received her BA from Smith College in Sociology and Women's Studies and is fluent in Spanish. And we also have with us somebody who's really unique in the sense that he doesn't practice in the U.S. With immigration here. He's actually from Spain. Markus Gonzalez Beilfuss, is that right? Or Beilfuss. Since 1992, Markus has been a professor of constitutional law at both Barcelona University and the Universitat Oberta de Catalunya, which I'm sure I just butchered. Previously, he was Immigration Director General of the Spanish government and legal advisor of the Spanish Constitutional Court, and he has research and advisory experience with a number of international institutions, including the United Nations and the Venice Commission of the Council of Europe. And Markus is currently a visiting scholar in the sociology department of John Jay College. So, what I want to start by doing is having Lindsay and Jennifer, since they work with really unique and awesome organizations, to talk a little bit specifically about what the organizations do, because they both do something a little bit different. So do you want to start?
Sure. Okay. Hello, everyone. I work at the Florence Project. Florence Immigrant and Refugee Rights Project is the long name, and we are a legal services organization. So we kind of call ourselves sort of like a quasi-public defender type system for immigrants in removal proceedings. So as we've talked about today, and everybody here probably knows, the immigration system is a civil system. So people are going through court proceedings, and oftentimes they are detained. They can't afford to hire private counsel to represent them. So the Florence Project was founded in 1989 to kind of address that inequity in the immigration system. It was actually founded by a plea from an immigration judge who was working in Phoenix on that docket, but when they started detaining Central American refugees in the town of Florence, at the time there were about 150 beds at an INS facility there. He was going down to do detail at the immigration court down there and realized there were a ton of people that had very strong asylum claims, but he found himself kind of being the one to sort of try to vet those claims, and that saw that there was no kind of legal resource for people that were going through this process, even though they had really strong claims. So he basically wrote a letter to the private bar in Arizona and said, we got to get some attorneys down to this remote prison town to try to advise people about asylum law, advise them about how to maybe get out of detention on bond and how to pursue their cases. And so one attorney managed to convince his law firm to pay for him to come down to Florence for a year to kind of set up this pro bono project. And that's how we were started. So we grew. At that time, we were working with about 150 people detained at that INS facility, and we have now expanded. We work with a little more than 3,000 each year. This past year, we served basically about 10,000 men and women and unaccompanied children. And we've gone from one facility to 6 adult detention facilities and then 7 separate facilities for unaccompanied children. So as immigration enforcement around the country and in Arizona has kind of skyrocketed, our population we've served has grown a lot as well. We have a staff of 16 people, and the type of services we're providing we call them pro se services. So because our staff is small and the population is very large, we don't represent everybody. We represent a very, very small number of the people we're working with. Instead, we provide what we call pro se services, know your rights presentations to people before their first court hearing about what's going to happen in court, how they might get out on bond, and what their defenses to deportation might exist for them. And then workshops and group and individual support for people to represent themselves. And then we try to recruit attorneys in the community to take our cases pro bono. So that's kind of a snapshot of what our services look like. We see people from about 90 different countries each year. So it's a lot of people from Mexico, a lot from Central America, but we have people detained from all over the world in Arizona. Roughly half are actually California residents that are in Arizona because of the detention bed space. But that's just a little overview of kind of how our program's structured.
Hi, I'm Jennifer Friedman, and like Rania mentioned, I work at the Bronx Defenders, and I'm the supervising immigration attorney there. So I want to explain a little bit about how our immigration practice works. We have now actually 6 dedicated immigration attorneys housed at the Bronx Defenders, and our immigration practice is somewhat different in that we are part of a holistic public defender's office. So what that means is that the Bronx Defenders started off as a public defender's office representing people who have been accused of crimes, and we are now, I think, representing close to 28,000 criminal defendants in the Bronx every year. And from that point, the office has grown. We now also have a family defense practice in which we represent 1,000 parents who are accused of abuse or neglect in their family court proceedings as well in the Bronx. And the model has expanded to with the idea that an arrest is never an arrest, and being enmeshed in the criminal justice system brings on and affects all of these other matters. So we also have a civil practice, and our immigration practice is in the civil action practice. We have housing, public benefits, employment lawyers, and we also have our immigration practice. So within our immigration practice, we are doing deportation defense. We are also doing plea consults. We're working with every non-citizen who's arrested and represented by the Bronx Defenders in helping advise their criminal defense attorney and work with them to try to mitigate the impact of that arrest on their immigration status, trying to avoid detection by ICE when possible, and when it does result in a removal proceeding, move from the criminal court context into the immigration court context and represent those individuals in their deportation proceedings. And being housed at the Bronx Defenders gives us the opportunity to work hand in hand with the criminal defense attorney, who may still be handling open criminal defense, criminal cases, or give us the power to sort of resolve those criminal cases in the way that is best suited to set us up for the best possible outcome in immigration court, and also have that information at hand. It also allows us to work in the family court context when our clients have coexisting family court cases, and we have on hand social workers, investigators, other civil advocates who can also help us in housing. So the model of the office is that we can all work together in those coexisting problems for our clients. So a lot of our clients are detained straight out of New York City Department of Correction, Rikers Island, and transferred into ICE custody and placed in removal proceedings as a result of an arrest. And we can talk a little bit about that.
Well, actually, that's a perfect opportunity to sort of segue into what we want to start with, which is enforcement. How is it that immigrants end up in the system to begin with? And I wanted you guys to talk a little bit about your specific organizations because, Lindsay, you deal just specifically with immigrants facing deportation, whereas Jennifer deals with both, the criminal justice system, but then you get the immigrants that you guys represent in deportation proceedings, you actually get them through the criminal justice system. So it's not as though you seek them out, right? So in terms of enforcement and how these people go into the system, I think you can't really have that conversation without first talking about the discourse that surrounds immigrants and the word immigrant. It's sort of become a word that's equal to criminal in lots of people's minds, right? Because of the discourse that we have in this country, particularly that comes from the right, where they're illegal and they're particularly violent and just all these awful things that we hear and these awful stereotypes. And so, why don't we turn to you, Markus, in Spain? Do you all have a similar? What's the discourse like? Does that affect the way that laws are enforced? Is there that sort of stereotype and bigotry towards immigrants that we have in America?
Yeah, okay. Thank you, first of all, for inviting me to take part in the discussion. I would prefer maybe to just, because I'm not going to Spain to talk about the United States. I have no idea about what's going on here. Just listen, and I'm surprised about some things that I hear, and I want to know a lot, so I have lots of questions, no answers. So I would talk about my experience of Spain, and I would, if I had to give a title, I would say the case of Spain, the development of a new immigration system, because Spain has changed a lot in 20 years. We were an emigration country, and in 20 years, we are now an immigration country. In a very short period of time, everything changed. To give you some numbers, 1995, when Spain became a member of the European Union, there were 250,000 people that were foreign citizens, 250,000. In the year 2000, there were 1 million. Now, 5 million, 0.4.
Wow.
So it's a big increase. Today, with our population of 84 million, it's between 10 and 11% of the population of Spain is foreign national or Afro national. So we had to, and when I talk about we, I would say the Spanish society, had to build up a new system for this new reality that has changed Spain in a very fast way, I would say. And then the crucial question was, well, how are we going to do it? We need a new legal regulation that tries to avoid what we heard this morning about lottery, that has to give rights. And our law is, the name of the law is important. I think it's the organic law on immigrants, I would say better, on the rights and freedoms of immigrants and their social integration. This is the name of the law, which says a lot about which is the main aim of this law. Mm-hmm. And we had also to decide, well, how are we going to manage immigration in the Spanish administration? We had the problem, okay, who has the competence? Here you have lots of problems between federal and the local authorities that take very important decisions. In Spain, at the constitution, it was clear immigration and asylum will be an exclusive competence of the central government. So there are regions that have lots of competences in the integration of immigrants, for example, health system, education, etc. There's competence of the regions, but they don't have competences regarding the legal status of immigrants, which gives a lot of also makes it. Or for example, only the state police can fine an immigrant or can deport an immigrant, which avoids lots of problems that I think that you have in the States.
But so it's the local level doesn't deal with immigration issues.
It's just the national police that has this competence. And then we had also to decide, well, who is going to take the decisions at the government level, at the national level government. And there, in the year 2004, it was the socialist government took a very important decision that is saying, okay, the competence in order to coordinate the whole policy regarding immigration will be a competence of the Ministry of Labor and Immigration. They changed the name. Why? Because in Spain, migration flows are labor flows. So it's quite logic for us to say, well, it will be the labor ministry who will decide, how are we going to coordinate the migration?
That's really
which
fascinating.
Is completely different. So, and I was first at the Constitutional Court, dealing with a very important case that maybe we'll talk about. It's, one of the questions of the case and was concerning the law, the Spanish law, was can unauthorized immigrants have the right to demonstrate, to strike? Do they have this right in the Spanish constitutional system? The court decided yes, they have. So it was very interesting to how to give the solution. And then I went to the government, just taking the step there and deciding, well, how are we going to regulate the details in the European context, which is very important in Europe and the European Union. The European Union has always a lot of competences, so we are not free in order to decide how we're going to regulate this. The limit of the European guidelines are very.
Well, before we get too into the legal stuff, I actually want to go back and step back a little bit and go back to the enforcement. And Lindsay, you're in Arizona, where some of the most draconian laws in the country are on the books in terms of detaining immigrants. So, what's your experience been with your clients? How are they picked up? How do they end up in the system?
Somehow I made it out of the fiery pit of hell of Arizona together. It's not that bad. I'm sorry. No, I'm just kidding. No, it's interesting. It's actually kind of a lovely place to live, but it's good to know that we're still outside the realm of what's considered normal in the rest of the country. So that's good. I think most of the people here in a lot of the presentations this morning really did describe pretty well how people come into this system, and we see a lot of that in Arizona, obviously. So obviously, given the proximity to the border, the facility I was talking about before, the main facility in Florence, which was run by INS and now is run by ICE, is actually a staging facility. And so about 50,000 people go through that facility each year in the last couple of years. That's sort of the most recent figure that ICE gave us. And so the majority of those people, I'd say probably about 60%, are recent migrants that cross the border. So as I'm sure people that are familiar with kind of border history and policy know, a lot of the border enforcement has kind of pushed people to cross more in Arizona. In the desert, much more dangerous journeys. A lot of people are dying in the desert each year. And so we have a high number of apprehensions on the border, and people are processed through Florence. A lot of those people actually don't have a right to see an immigration judge unless they express a reasonable fear of returning to their country of origin. So most of them are in a process called expedited removal, where they don't have an opportunity to see a judge or raise a defense to deportation, and they're just ordered deported administratively. And then I'd say about 40% of the people we see are people that have lawful status. They tend to be green card holders, but they're in removal proceedings because of some interaction with law enforcement getting pulled over, as we heard about, driving, or low-level crimes or arrests. We have a lot of people that interact with law enforcement because of like domestic violence situations that get picked up. Obviously, Sheriff Joe in Maricopa County has these posses of community members who are going out, and they have a phone number where you can call and report if you think your neighbor might be undocumented, and they will go out. So a lot of people are obviously coming in through his system. And as I said before, about half of the people detained in Arizona that we work with are from California. So we see a lot of, obviously, people coming in through border enforcement, but then a lot through this interior enforcement as well.
So that's really interesting that you bring that up because, Jennifer, you specifically work with, your organization specifically works with people who come in from the criminal side. And in a lot of places in the country, if you have a felony, right, if you get convicted of a felony, and then, you automatically get turned in if you're undocumented, right, like to ICE. So, Jennifer was telling me how in New York they recently passed a law that regulates who law enforcement can turn over to ICE. So do you want to talk a little bit about that?
Sure. Before I get to the law, I'll back up just a little bit and talk about how our clients come into contact with ICE. To begin with, we do a lot of preventative work to try to keep our clients from coming in contact with and trying to avoid entirely any kind of immigration enforcement enforcer. So, in New York in New York City, we don't have ESCOM, we don't have police handing people over directly, but what we do have is the Criminal Alien Project CAP and in all of the jails. And so when someone is incarcerated in New York City in the Department of Correction, ICE agents are there and they're going to drop a detainer. So we do a lot of work with people who have been arrested and may be out of status and therefore are going to be subject to a detainer if they are held in custody. And then we also have a large number of people like the ones that Lindsay talked about who are lawful permanent residents who have been living in the country for who knows how long, 30, 40 years, and may be subject to removal from the country because of minor or not so minor criminal convictions. So a detainer, what a detainer is, just very briefly, I assume that most people here know, but what a detainer is that it's a request from ICE to a local jail to hold an individual. ICE will identify someone who they think is deportable when they do sort of a preliminary assessment for someone who's in jail. And they will issue a detainer, which is a request to the local jail to hold that individual for up to 48 hours after the criminal proceeding is over for them to have ICE show up to pick up that individual and transfer them into ICE custody. There are a lot of problems with detainers. There's no pushback. There's misidentification of people who are deportable or subject to ICE enforcement. The law that Rania and I were talking about before the presentation today is actually a huge success that we've had here very recently in New York City, and it's actually just gone into effect yesterday. So we're just at the cusp of getting to enjoy the fruits of that. But a coalition of community activists working together starting last year were able to get the City Council, the New York City Council, to introduce and ultimately pass a law that puts a limit on who the New York City Department of Correction is going to be handing over to immigration for those enforcement. And what it says is that if you don't have a criminal conviction or an open case or a warrant and you're not identified in databases as a gang member or a terrorist and you haven't been ordered deported from the United States before, there is no other outstanding immigration warrant as an absconder warrant. The New York City Council decided that we are not going to be allowing our Department of Correction to hand those people over to immigration. So we are going to cut out the most unjust feeling sector of those people who are caught up for enforcement because they've been arrested but then ultimately not found guilty of having committed a crime. And so we're not going to respect those detainers. We're going to not hold those people for 48 hours. We're not going to let immigration know when their criminal case is over, and we're going to release them back to the community. So that was signed into law last November by Mayor Bloomberg, and it had a implementation time during which we've been very lucky to be working with Dr. Shiro and her office towards effective implementation. And that law has taken effect as of yesterday. And so we're very excited to see what we're going to be able to do moving forward in terms of limiting somewhat who is going into ICE custody as a result of that. The law is limited. It has a lot of limits. It is still allowing all of those lawful residents who have low-level or 30-year-old convictions to be handed over to immigration, and we'll continue to be fighting on those people's behalf. But it's a very exciting prospect, and there were a lot of community partners, some of whom are also in the room today, that made that possible. The law is called, I have it written down, Local Law 2011/062, I think. But it's called, and then the subtitle is, I think, People Not to Be Deported. Or wait, I have it here somewhere. Persons Not to Be Detained.
It's very straightforward. So I think a lot of people outside this room would be, and maybe some people in this room would be kind of shocked to know that a legal resident can be deported for, having a conviction. Who wants to talk about that a little bit? And just to add one thing, I mean, there are some, it's rare, but and if you've seen this, please speak about it. Situations where actual American citizens end up being detained, and there's been some cases, a few of them, where they've actually been deported. So yeah, who wants to, please?
I'll start that off talking about sort of the low level crimes that can lead to deportation. You mentioned felonies, and it's a really big misperception that you have to have a felony in order to become removable if you are in the country with status, and that's just not true. I actually represent a young man who is a lawful permanent resident right now, who's lived here. He's in his late 20s, and he's lived here since he was a child. He's currently in removal proceedings because he pled guilty to one non-criminal marijuana violation here in New York City. He was not arrested. He was given a ticket. He reported on his desk appearance ticket, saw a judge, was told to stay out of trouble for a year and pay a $100 fine. Then he traveled back to his country, and trying to re-enter was stopped and put in deportation proceedings. That is not a misdemeanor in New York State. He probably was told that it would not count on his criminal record, that it would seal after a couple of years. Unfortunately, at that time, he was not given the information about what it would do to his residency status, and now he is facing possible deportation. So low level, marijuana, non-criminal, here in New York City, we have these what are called violations that are they're below misdemeanors, they're non-criminal violations of the law for which you can receive a maximum of 15 days in jail, but you almost always just get a fine or what we call a conditional discharge. One or two of those marijuana violations make people deportable, and I actually also represented someone who had two and was detained for 8 months in the Department of Correction custody while we fought to reopen and change the outcome of one of those, because even though this wasn't an aggravated felony, he was not also going to be eligible for discretionary relief because of time barriers. Another favorite example that we like to talk about is how jumping the turnstile twice will make a lawful permanent resident subject to deportation, because those count as crimes of moral turpitude, because our New York statute, theft of services, is a theft offense. Theft offenses are inherently vile, depraved, or evil, and so too will send a lawful permanent resident home.
What about littering? No, I'm sorry, that was a bad joke.
I'm sure you have.
Oh yeah, please speak about it.
To kick it off.
Yeah, I mean, it's the exact same for us. But I think just to step back too, I think, and this was touched on a little bit earlier too, is the reason this exists is because of the kind of parallel definitions of what is a crime in criminal law and then in immigration law. And so under the Immigration and Nationality Act, a lot of offenses that are misdemeanors under criminal statutes are considered aggravated felonies or deportable offenses under immigration law. And so you have this crossover area. It becomes an extremely technical area to practice immigration law. So deportation defense attorneys are usually extremely knowledgeable about this area called criminal immigration law. It's the type of thing, just going back to sort of the due process issue, that we find really challenging to help our clients try to raise those issues pro se, because they're technical legal arguments. But they tend to be the cases where we're able to be most successful because, how do I put this nicely? The ICE prosecutors aren't always the experts in this area, and so they will tend to kind of use documents that technically aren't documents that they should be able to judges should be able to look at in order to decide whether someone is going to be deported or not. And so if you can get really good defense attorneys that are knowledgeable in this area, you can basically challenge the basis of somebody's removal based on whether or not ICE has sufficient evidence to prove that they've actually been convicted, or to prove that crime is deportable under immigration law. So it's this really technical area that a lot more immigration attorneys are practicing in. And so as depressing as it is, it's also an area where I think we can really hold the ICE prosecutors more accountable and win more cases. And especially related to that are these citizenship cases. So we screen probably about 50 cases a year where we think people might have a claim to citizenship. A lot of these people give up because they don't want to stay detained, and so they'll just take a deportation because they're going to be detained for months and months and months and maybe years in order to prove their citizenship claim. But a lot of the cases that we are able to get those proceedings terminated based on citizenship by basically pushing ICE to prove it, or helping somebody acquire the documentation they need to show that they've acquired citizenship through a parent. So it's a depressing area, but it's also one where we're seeing the immigration bar and criminal practitioners really start to gain a lot more technical skills in, and it's one way to kind of hold ICE accountable more in these deportations.
So on that note, I think it's important to point out that when dealing with immigration proceedings, immigrants have no right to legal representation in our country. So Markus, what I find interesting is that in Spain, they do have a right to an attorney and representation, and it's a human right, from what I understand. Do you want to talk a little bit about that?
Yes, immigration law in Spain is a part of administrative law. It regulates the relationship between a person and the administration. This, for us, is administrative law, not civil law. So there are some guarantees that have to apply also to immigration law. Which guarantees are these? Well, the first one is a constitutional right, the due process of law. In our constitution, it's a human right. And then in this decision I was talking about, the Constitutional Court, the question was, well, do immigrants have all human rights that are in the Spanish Constitution? The Constitutional Court said, okay, not all of them, but those who are essentially related to human dignity, these are also for immigrants, with the same content as for national people. And one of the examples of these rights is due process of right, that is related to human dignity in our system. So if you have an administrative proceeding, you have due process of right with the same as a national. So there's no difference. And because it is administrative law, other guarantees are also very important. For example, the proportionality between your behavior and the sanction. And therefore, for us, it's not all violations of immigration law can have as a consequence deportation. Some of them, the most important, yes, but not all of them. And the first sanction would be a fine. So if you have any document that is irregular, then you are fined. You have to pay. Deportation is the last sanction of the proceeding. It's just the application of this proportionality proceeding or principle in immigration law, because immigration law is not an extraordinary law. It's a part of a legal system in a constitutional country, I would say. And therefore, of course, there are then problems, no? Because in immigration law, you have to decide very fast about things like, well, deportation, when there's possible. You have to decide in the border, you have to make it very fast, so there are special regulations. No? But in general, the system is quite obvious for us, and nobody discussed this. It's assumed that it's obvious that you have legal representation.
So I want to point out that I found this statistic statistic is that immigrants with legal representation are at least 5 times as likely to win their cases, which makes sense, right? It's pretty obvious. And then, first there was a study in New York that showed that in New York only 40% of detained immigrants have lawyers, which is probably something that you were both familiar with. But so I wanted to mention that in 2010 there was a Supreme Court ruling that basically ruled that criminal lawyers are required to explain to their clients the consequences to their immigration status should they plead guilty. Am I saying that correctly? So how do you guys see that sort of possibly evolving into immigrants having a right to, public defense? Do you see that happening ever? Do you see that leading to it?
I mean, hopefully it would lead to a system like the Bronx Public Defenders has, where you see like a collaboration between the immigration and criminal. But I think and there are a lot of states, Arizona included, that have some resources in place to advise public defenders and criminal defense attorneys about immigration law so that they can adhere to this Supreme Court precedent and provide advice to their clients. But as I said just a little bit earlier, it's an incredibly technical area of law. A lot of immigration lawyers are not up in these kind of intricate criminal immigration issues, and so I think it's going to be an issue of capacity. So places like New York City that are perhaps more willing to kind of invest in their public defender system and invest in ideas of like holistic services are going to be able to kind of embrace this kind of requirement. Places like Arizona that are the opposite, basically the resource we have in our state is one part-time attorney who works for the Florence Project. And she basically takes phone calls from public defenders and criminal defense attorneys around the state and advises them on the immigration consequences of their convictions. We, at this time, don't have any funding to kind of continue that position, and it's one person. And so everybody in the state knows her and knows how to get a hold of her. But there's been no investment in the public defender system in Arizona to try to kind of build this into their program. So I think it's going to kind of depend, but it's a really exciting decision because I think it does create that possibility that if states do invest in public defense, that immigration hopefully can kind of get included in that as it has in the Bronx.
Do you have anything to add to that?
I think that the immediate, the name of the case is Padilla, for those of you who are keeping track of that kind of stuff. And I think that the sort of immediate reaction to the Padilla decision has been a lot of criminal defense attorneys looking for ways to try to make sure they are giving non-citizens the accurate information that they need in a way that wasn't necessarily happening everywhere before, and hopefully avoiding some of the situations like I was talking about, and working out alternative dispositions, because it's a lot easier to avoid getting put in deportation proceedings than it is to win once you're in deportation proceedings. And so I think that Padilla has gone a long way in raising the defense bar's awareness about the need to be seeking out that advice. And especially here in New York, we've been very fortunate that there is funding for that. I think that both, I don't know how directly Padilla will lead to a right for representation in removal proceedings, but again, here in New York, we've been lucky that the study that you mentioned, Rania, has also raised awareness about the need for non-citizens facing deportation to have representation it really raised awareness around that. We've also have opportunities to expand the immigration attorneys that are available free of charge for people who are facing removal here.
So here's one thing that's really upsetting is that so immigration detention, right? There's also this aspect of detention, while they're waiting for court proceedings, while they're waiting for, are they going to be deported or not? They spend these times in these immigration centers, which we've all heard horrific stories about, right? Some of which are these private detention facilities, which are even more horrific, and it's all awful. So it's really interesting that immigrants who don't have legal representation are more likely to be sent to facilities that are like states away, which I think is really sad and interesting. Jennifer, you were telling me about how you have clients who you guys fight to keep close to New York, right? So do you want to talk a little bit about that?
Yeah, the issue of transfers is one that has been a big problem for a long time. And there's actually, to start with, there's a pretty new detention transfer regulation that I haven't actually seen how much in play it's changing this. I don't know if you have, but historically immigration detention is a federal system, and so it's spread out all over, and once immigration picks someone up and has them in detention, they can detain them pretty much anywhere they want, and there aren't enough beds around New York to detain everyone that was picked up in New York and put them in proceedings here in New York. And so there has historically been a huge pipeline of New York immigration detainees being sent down to places like Texas, a huge number of them going down to Texas and being in immigration detention centers along the border where they are, and Louisiana and other countries where states, they feel like other countries sometimes. Where they don't have access to the same kind of free legal resources, or they're isolated from friends and family. They can't make phone calls because it costs like $20 to make a $3 collect call. Family can't go and visit. So the isolation, coupled with the length of the detention, and the lack of legal resources in like a far-flung corner of Texas, feels like you're a stone's throw away from being deported anyway, really adds to the sense of hopelessness and lack of information that those folks are facing. What we have done, and we've been very successful in now being able to keep people here so that we can represent them in their removal proceedings when they are seeing a judge here in New York. Those individuals are detained in beds in local New Jersey jails, county jails, where ICE has contracted for bed space with the county jails. And our clients regularly tell us that being in jail in New York City was so much better than being in ICE detention because, at Rikers Island and in other New York City Department of Correction centers, you have more chances for movement. You can get a job. You might be able to do a drug treatment program. There are more opportunities for treatment, for programs, for different kinds of things. And then once you get sent to a jail in one of these rural New Jersey counties where you have contracted bed space, there's oftentimes less outside time. There's no drug programs or alcohol programs in most of those. There are fewer opportunities to do things that are ultimately, this is going down another path, but less mental health treatment. And the lack of that kind of treatment opportunity is also something that's going to end up prejudicing them in the merits on their discretionary deportation application.
And I'd love to hear from you as well, Lindsay, where your clients usually end up being detained. And on top of that, also, back to this culture of, criminalization of immigrants, of this idea that they are criminals and should be treated as such. Do you think that sort of spills over into how they get treated in these immigration facilities?
Yeah, absolutely. I mean, so we don't have an issue of people getting transferred out of Arizona because we have so much space. So not as much as Texas, I think, has about 10,000 detention beds. So they're the site for a lot of transfers from the East Coast. But so we have people coming in instead of people going out as well. But just to tell, so the Florence Project is working with people in sort of the three main types of ICE facilities. So the staging facility I mentioned earlier is a facility that's actually owned and operated by ICE. And that is by far and away the best of the facilities to be at, because from the beginning it's kind of had more of this kind of civil detention culture to it. Now it's still a prison model, or as Doris Schriero said, they sort of focus on control, borrowing from the corrections model. So it is still very much a prison, but it's much more humane in terms of people's freedom of movement, people's access to things like outdoor recreation, the quality of food. I mean, and these are all incredibly important things when you're stuck somewhere indefinitely for months and months and sometimes years. And then we also work in 3 different facilities that are run by Correction Corporation of America, so these are the private facilities. One of them is 1,500 beds in the town of Eloy, which is about 25 miles from Florence. And then 2 other ones are right in town in Florence, and there are about 3,000 beds each, and they share contracts with ICE and with the Bureau of Prisons and with the U.S. Federal Marshals, and so they're kind of mixed populations. Those facilities obviously vary in terms of their conditions, often just in terms of who's running them, but some of the chronic issues you see in the private prisons are things like constant understaffing. There's just never enough staff to be able to kind of do things like bring somebody up for a legal visit on time, and less obviously investment in programs, if any, and just things like that, medical care and things. And then the third type of facility where the majority of people around the country are held are in existing county and state prisons and jails. And these counties and states contract with the federal government to hold people. So just like there's a profit motive for private prisons, that same profit motive exists for counties and states. And so the newest facility that we work at in Florence that opened in 2006 is the Pinal County Jail, run by Sheriff Paul Babu. I don't know if people are familiar with his recent scandal that happened as well. So they basically went into a contract with ICE where they kind of refurbished a wing of the county jail, and so there's now a 625-bed ICE wing where people are held. And this facility is by far the worst in terms of conditions. There's no outdoor recreation. So people that are held there have absolutely no opportunity to go outside. I represented someone there who just got released after 6.5 years. And he spent 3 years at that county jail and never went outside, other than when he went to court, which was like 3 times in 3 years. All of visitation is by televideo, so you don't get to visit with family members in person unless an attorney makes a contact visit request. You're not able to see your attorney in person, and just quality of food, quality treatment sort of by guards, everything about it is incredibly punitive. And then I'll stop, but one interesting thing that's been kind of eating away at me when I think about kind of the differences in those facilities is, and I thought about it this morning when Doris Schriero was talking, is that ICE is talking about kind of a more civil, humane system and that it shouldn't be punitive. But the people that they put in that facility, the quote-unquote worst facility, which local ICE acknowledges is the worst facility, are the people that are quote-unquote level 3. Now to them, level 3 is the most serious. So the people that have the more serious convictions are the ones that are being put in that facility. So it just makes you wonder, like, if this isn't punitive, why are you putting the people that you say have the most serious convictions in the worst facility? And again, these convictions are things like my client who was there for 6.5 years had one conviction for selling $20 worth of crack when he was 19 years old in Miami. So these aren't quote unquote really serious convictions. So, but just that idea of like, if this isn't punitive, why are you separating it out, sort of the more punitive facilities going to sort of the more dangerous people, so.
It's a very good point. And, in terms of private prisons, which I'm a little bit more familiar with, 'cause that's something that I've written on, I was talking to Markus about this, and he mentioned that in Spain, private prisons are illegal. You can't have a private prison, is that right? Or a for-profit prison?
They don't exist.
They don't exist, that's it.
The detention centers are always run by the Ministry of Interior. It's public. There are no private.
And what's the treatment like in those facilities from your experience?
we have also the debate. I mean, they are defined in the law as non-punishment installations or facilities, because their main aim is just to make deportation possible. So this is the aim, it's not to punish. And therefore, we have a time limit. I mean, just to be in a deportation center, first you need the authorization of a judge. It's not a decision of the Ministry of Interior. It's a judge that authorizes that you go to the deportation center. And then there's a time limit, because the aim is just to make removal possible. If removal is not possible, then you are free. This time limit is 60 days. It was 2 years ago when it was from 30 days to 60 days. It was a big scandal in the Spanish society, because most of the NGOs said that 60 it's too much, that you know before if you're going to be, if the person can be removed or not. If they cannot, because the state of origin doesn't accept him, doesn't recognize him, you know you are going, then you have to put them free. If not, you punish him. So therefore the system is different, although, of course, then there's the problem how to make this definition of a non-correctional facility real. No? Because, of course, if the facility was an ancient jail, then it's very easy to make it like a jail. And you need, of course, then social services, social health. And if not, if you are not able to give these services, then maybe it's better the jail than not a different system that in theory it is not, but in practice it can be worse because there's no services. So this is our discussion.
So another thing I wanted to touch on is, parents, immigrant parents who end up detained. What happens to their parental rights in this country? And then we can talk about what happens in Spain, which is far different. What's your experience been with that, Lindsay or Jennifer, or whoever would like to go first?
Mine's probably bad and yours is probably good.
So then let's start with you.
Yeah, let's start with the more depressing experience. We'll get more hopeful.
So it's not all depressed. Well, it is, but this is an area we've been working more on. So obviously we're focused on screening people for legal relief in immigration court, and so we're doing hundreds of intakes a day with people. And what continues to come up is, I don't care about my case. I want to know where my kids are, or I don't know where my kids are. Am I going to lose my kids? And so we've been trying to work in this area in the last couple of years by kind of pulling resources in from the community for parents that are detained and going through these proceedings, and then educating the child welfare community in Arizona about immigration detention. So currently what happens now is that what people tell us that work in the child welfare field is that if they identify a parent that's an immigrant and they can't find them, they quote unquote disappear, they're gone. And the scary part about that is a lot of people that work in that system that aren't that educated about the immigration system just think if someone is in immigration, they think they're deported, or they think their deportation is inevitable because they're in Arizona and they're an immigrant and their immigration has them. And so a lot of the work we've been trying to do is to educate caseworkers, and when dependency proceedings are started for children that are in the child welfare system, the parent is actually assigned an attorney to represent them. And we've actually worked with a lot of dependency attorneys that we have talked to the parent in Florence and then figured out who their attorney is and called their attorney and said, okay, here's your client, and your client has a case under, say, the Violence Against Women Act. She's going to get out. They still think that they're going to get deported. Now, that's not all of them. A lot of the attorneys are really good, but it's just creating kind of communication there. And so we've been doing a lot of sort of trainings and meetings with the child welfare system to kind of educate them on how to locate a parent, how to make sure the parent can visit with the kids or can write letters and things. The area that is more depressing, where we haven't made any headway at all, is basically advocating for release of that parent through ICE. So you would think that in these sort of recent announcements about prosecutorial discretion and only detaining people that are sort of more serious, people that have criminal convictions, that parents of U.S. citizen children that might have their parental rights terminated could fall into that category. But We really haven't made much headway at all with ICE, where we identify a parent who's about to lose custody of their kids, that that's somebody where they should release them or at least transport them so they can appear at the dependency hearings, or make arrangements so they can be deported with their children. We haven't seen a lot of movement in that area at all. So it's very real that there's a huge consequence on permanent separation of families through immigration enforcement.
Like I mentioned, we also have a family defense project at the office. So we do have clients coming in who haven't necessarily been arrested, although some may also have coexisting criminal cases. But they come into the office solely because they do have a family court case, and some of those people are, put in deportation proceedings as a result of a coexisting case or whatever, but we have an opportunity to sort of work together with the Family Defense Project at the office and the immigration practice at the office to think about the way that the two systems aren't working, and have also been conducting trainings with parents' attorneys around the country to try to help them figure it out. And we find the same things, first of all, that a parent's attorney doesn't know how to contact, or the child welfare system, or no one, the representative of the child doesn't know how to contact a parent once they're in immigration detention. It can be almost impossible to find them, especially if you don't have a full name or a name number or know where they are. And then, if there is a plan, if the child has been removed from the child's care, there's going to be a plan put in place that the parent has to work towards for reunification. But when they're in immigration detention, that is going to be impossible, because it's going to be things like find stable housing, find a job that we can verify, do a parenting class, do a substance abuse class. And even so, if you're detained, first of all, that's all impossible, especially if you're detained thousands of miles away from your attorney and from your family. But even in cases where these parents aren't detained, being an immigrant is still a huge barrier. Just even getting service providers to take our clients who aren't Medicaid eligible because they're undocumented. You can't get into a substance program because they're not a substance abuse program because they're not going to be reimbursed because you're not eligible for Medicaid. There's language barriers, and we also see a bias against undocumented relatives taking children on. I think that we are lucky in the Bronx. It hasn't been as big of a problem. I've heard from providers from across the country where the courts won't place children with family members if they're undocumented. We have had luck with that happening, although there is pushback, and there's always a concern that why place, it's not in the child's best interest to be living with someone who could be deported at any time. We recently participated in a study, a really great report that was put out by the Applied Research Council on this issue, where they did a really great assessment of all of these issues. I was going to say make another point, but I can't remember. But
well, if it comes back to you, feel free to chime in. But so I just wanted to point out that between January and June of 2011, the United States carried out more than 46,000 deportations of parents of U.S. citizen children. And that was data that was compiled by the Applied Research Center, which is, I don't know if anybody reads Color Lines, but it's a wonderful publication, and they did this really intensive investigation using this federal data. And as a consequence of that, there's now 5,100 children in foster care who face barriers to family reunification because their mother or father is detained or deported. So that's a terrifying statistic, right? That these families are broken apart in such an awful way, and oftentimes, and actually, I don't know if either of you have worked with after a parent has been deported, trying to get their children reunified. I don't know if you've worked with that at all, or if you've experienced that, to where like the children are in foster care and a judge won't allow the children to go live with their parents in whatever country they've been sent back to. Have you all?
That was the point.
Oh, okay, great.
I don't actually have a story where I've specifically worked with someone, but it is something I've heard. I think that people doing this work on the border have been really pushing it and having better success. But even in those cases where a judge is open to take it into consideration, and you can, there's a whole bunch of things that have to happen. You have to be able to locate the parent who has been deported in Mexico or wherever it is, which can be tough. And then there has to be, like a family study conducted by a social worker, and It all has to be coordinated through the different governments before the judge or the child welfare agency here in the U.S. is willing to give up supervision of that child and send them back to the other country.
Yeah, I mean, I'm familiar with one case that's with an outside pro bono attorney, so I'm not working on it. But I think all of that is true, and the consulates have been really good resources, I think, in these cases because a lot of this stuff has to get set up. But the other thing is these cases tend to go on and on and on, and this one case has been going on for like 2.5 to 3 years. And at this point, I know the client's been deported to Mexico. She was deported about a year ago. She's trying to keep her 3 kids who are with a foster family. You also have this dynamic with the Adoption and Safe Families Act, where kids are under a certain age. They want resolution for them, and so you have these timelines that with immigration law and with dependency law that really conflict. And there is some truth to, giving young children sort of certainty about where they're going to stay, and the idea is that having them in limbo for a long amount of time is detrimental to them. And then you also have this dynamic where foster families are more willing and interested in adopting young babies, and so they want to have resolution for that. But I was just going to make the point that these cases drag out really long, and I know this one woman who's going through it right now is kind of at the point where she's kind of ready to give up and feels like, why am I going through all this to bring my kids back to Mexico where I am, which is where I left in the first place because I had no resources to support them. And so you're putting people in this really just devastating situation where she might elect to terminate her rights because she's been through this process for so long and just doesn't necessarily want to put her kids through it anymore. And she has to make the decision about whether the kids might be better off if she isn't their mom, which is just kind of hard to even wrap your head around.
That's chilling. So I really want to let you guys ask some questions, but really, really briefly, Markus, do you want to just talk about, quickly explain how in Spain, how that works with the reunification? Because I thought that was amazing and fascinating.
Well, there are big differences because, Spain, I would say the whole Europe it's different from here because most of the countries, first, they have ratified the international conventions relegating children, where the superior interest of the minor is the key value to protect, and therefore the whole regulation has to look after this first. And secondly, because there is a recent, 6 months ago, decision of the Court of Justice of the European Union, placed in Luxembourg, in a case that is more or less like if the kid or the children, if they are Spanish, which in our case is not so easy as here because for the being born in Spain is not necessarily gives you the citizenship. In our system it's different. But if it's the case, if the kid is Spanish, you have, as a state, you have to protect Spanish people. And a way to protect Spanish people, Spanish children, is to legalize the parents if they are irregular. So in our system, it's a way to get documents. Because if not, you are not protecting your citizen. So our system is, I would say, completely different. This isn't the case if the children are Spanish or European or citizens of the European states. If they are not, then because of the international treaties, the decision of removal has to take into consideration these facts. For example, you can't remove a parent during the school period, for example, if the children is going to be alone, because you have to you have to wait till the school term ends just to make deportation possible. Or if there are special ties with the society, maybe you can't deport. Because as I said before, deportation is not the only consequence of the sanction. It has to be a proportionate sanction to what you committed. And in this balance, the value of the children, the superior interest of the children is to be taken into account.
So I want to spend the next 9 minutes, I guess, allowing you all to ask questions. Obviously, these people are so full of knowledge, so ask away. Who wants to go first?
Hi, thank you so much for this fascinating panel from a comparative perspective, which we hardly get. I'm from Spain, as it turns out. I've been living here for about 12 years, and Markus, listening to your presentation, I bet most of the people in this room, they just want to move to Spain because it seems like it's paradise. But you know what? It doesn't really correspond to what I've been seeing. Every time I go, everything you presented sounds perfect on paper, and it looks perfect on paper. And of course, we have to start somewhere, and that somewhere in this case is legislation, recognizing human rights and basic rights. But I would like you to, come on, talk a little bit about xenophobic crimes and the huge anti-immigrant backlash right now. Huge in Europe, not just Spain, but Spain, Italy. I mean, of course, focus on Spain, which is your thing. But I think we should bring that component into the picture so that the audience really understands all the social forces playing a role right now in the really everyday reality of immigrants back in Spain. And by the way, now we see a movement, people are leaving for the first time in about 15 years. The government is giving back Social Security benefits in cash so that, to encourage, because of the crisis. Now we have a 20% or above of unemployment rate. So of course, immigrants don't fit right now. But I'm sorry. It was supposed to be a question. And very quickly for Lindsay and Jennifer, I've been asked to be expert witness in a few deportation proceedings cases, and I always wish I were briefed as to, since you're so experienced, once we go in front of a judge, what is the judge really going to react to? Like, I never know. We have so much data, but really statistics are, so flaky because these are hidden population after all. So what I have right now, a case of torture. What would you suggest that I present if I'm given only 10 minutes? And of course, case of torture, if the judge doesn't consider the eyes wink is torture enough, I mean, I don't think they're going to buy into what I present. But whatever suggestions will be really appreciated. Thank you.
So that's a two-part question. First part for Markus. Can you talk a little bit about the cultural context surrounding immigration laws, xenophobia, et cetera, in Spain? And the second part for Lindsay and Jennifer. What are asylum judges looking for from an expert witness such as Yolanda?
Well, the question to be answered, I would need a lot of time.
Yeah.
Of course, I was just talking about the general ideas of the system. The system, of course, in practice has lots of problems. It's not so easy to manage, but I think that it was interesting to, and I was asked to give just the guidelines because they try to, as I tried to mention, they try to answer the question is, which system do we want to have in accordance with a constitutional state that is in a concrete context. No? And the idea is, if we want a rule of law state for us, it also has to apply for the immigrants. This is the key, I would say, decision. Of course, in practice has problems, and we could talk about it. Now, of course, there's a crisis as a big issue. And because in Spain people came to work, therefore I talked, it was migration flows were labor flows. People, they don't come to Spain seeking for asylum, they come to work. Now with the crisis, of course, the first problem is, well, what's happening with immigrants and how this crisis affects the legal status. Because if you can't work and you have to renovate your permit, how does it work? And there are different decisions that were taken just to, in this new context, to help people to renovate the permits. Because it's obvious that people, they won't go freely, and it's obvious that you can't remove them. It's impossible. So you try to manage by this permit. Of course, there are different